Alrighty, we're back. June 11th, Thursday, June 11th, Economic Justice Law Review, Weekly Scholarship Digest. At the EJLR, we are the repository for scholarship relating to race, economics, and law. I'm your host, the director, Andre L. Smith, Dre Smith, 15 years in teaching AALS law schools, Widener, FIU, Howard University, Penn State. Shout out to everybody, all the critical folks, all the realist folks, even the formalists too. Everybody can get down with this. Because, I offer kind of a formalist construction of realism, if you can understand how I put that together or synthesize that. In other words, in talking about economic justice, we are using a fairly formalistic framework. Our thesis is, again, that racially asymmetric market imperfections and failures perpetuate the racial wealth gap. What do I mean by racially asymmetric market failures and imperfections? I mean that a supposedly free and fair meritocratic market under the neoliberal or neoclassical model that Gary Becker uses to say that the market will eliminate racism, that market does not exist, right? It assumes that free meritocratic market requires that everyone be a profit maximizer, everyone be able to compete in any market they want to, that there's perfect information, and that there are no transaction costs. If all those things existed, then maybe racism would be eliminated by meritocracy, but we know that's not the market that actually exists, right? We know that competition is asymmetrical. We know that information is asymmetrical. We know that the distribution of transaction costs is asymmetrical. We also know that those transaction costs are racially asymmetrically distributed. We know that information is racially asymmetric within the market with respect to information about black folks and information available to black folks. That racially asymmetric market competition is reflected in the racial wealth gap, human capital gaps, political gaps, and also we know that certain groups are encouraged to pursue the market more than others when we talk about everyone being a profit maximizer. And the totality of racism and microaggressions also cause some black folks to just withdraw from the system. So racially asymmetric market imperfections not only describes a racist or a market that is racist, it also demonstrates or explains how racism is not going to go away, but how that racial wealth gap will perpetuate and exacerbate well into the future. Again, racially asymmetric profit maximization or market engagement, racially asymmetric market competition, racially asymmetric market information, and racially asymmetric transaction costs and societal externalities. Those are our four pillars of a law and economics critical framework. And so what we do is we gather scholarship that's published in the law journals all across the country, and we recategorize them in terms of this framework. So the articles themselves may or may not reference economics. They may or may not reference race. But if the content of it reflects one of these racially asymmetric market assumptions or pillars or the infrastructure, then we bring it here and we place it amongst scholarship relating to race, economics, and the law. We got three hot topics today, three hot plates out of the law journals published around the country. Number one is Britton-Purdy and a gaggle of scholars. I think it's 4 different scholars on inequality in the 20th century synthesis, right? And that 20th century synthesis reflects racially asymmetric market failures and imperfections generally. I really like this paper because it is very compatible with the framework that we're working with now, and also a book that I'm writing called Afro-Atlantic and Jurisprudence, sort of a black nationalist approach to law and interpretation and jurisprudence, which I believe would combat the 20th century synthesis, as they call it. They would be Jedediah Britton-Purdy of Columbia, David Singh Grewal of Berkeley, Amy Kapczynski at Yale, and Sabeel Rahmana at Brooklyn, and also of Demos. They wrote a paper, published a paper, Building a Law and Political Economy Framework Beyond the 20th Century Synthesis. It's in the 129th volume of the Yale Law Journal, page 1784 this year. The second one we're going to feature is Kudekallua, who is a fellow, international fellow at Fordham, who's written a paper on caste and food discrimination. And we're going to put that within the rubric of racially asymmetric market competition. It is published by Ramya, Jawahar, Kudekallua. It's Race, Caste, and Hunger, 43rd volume of Fordham International Law Journal, page 1103, 2020. And then last but of course not least, we have Lamar-Campbell of Nova on transitional justice, school segregation, and the myth of black intellectual inferiority. And again, that fits easily within the rubric of racially asymmetric market information. And that is Camille Lamar-Campbell, Getting at the Root Instead of the Branch, Extinguishing the Stereotype of Black Intellectual Inferiority in American Education, a long-ignored transitional justice project. And that's in the 38th volume of Law and Inequality, a journal of theory and practice, and published this year, 2020. I just want to remind you guys, in previous weeks, last week we talked about Vanessa Berry's Racialism in the Media, Andre Perry's Know Your Price, Valuing Black Lives and Property in America's Black Cities. These were books as well, so we don't just do law review articles, but these were very good books that just got put out on the market. The Black Cabinet by Jill Watts, The Untold Story of African Americans in Politics During the Age of Roosevelt. In weeks prior to that, we published, we featured an article by Benjamin Idelson of Harvard, Respect Individual and Color Blindness, Issa Kohler-Hausman, What's the Point of Parity? Charles Lawrence did a review of Jennifer Eberhardt's book dealing with implicit bias. So two lions joining forces there. A Charles Lawrence review of Jennifer Eberhardt's new book. Sandy Darity talked about his book a couple weeks ago, Reparations, From Here to Equality, Reparations for Black Americans. And I want to just mention that because I guess it was the founder of BET, Bob Johnson, that just came out with a figure, $14 trillion for reparations to Black Americans, or ADOS, or however you describe it, which would amount to something like $350,000 a piece. Right? I've written with Carlton Waterhouse on taxation and reparations, so maybe I should apply a tax analysis to it, or should I just wait by the mailbox for my check? Hope we get it. The cause is just, the claim is correct, but again, where law meets power, right? I'm not holding my breath. Anyway, Isabel Wilkerson has a new book out, Caste, The Origins of Our Discontent. It's coming out in October, and I really wanted to mention that because we have another paper, because the paper on hunger and caste in India relates very well to that. So I just want to make sure that we are talking about similar papers so we can all get the full gist of it for those scholars that may consider writing on the subject. All right, so let's get at it. Featured this week, Jedediah Britton-Purdy, David Singh Grewal, Amy Kapczynski, and Sabeel Rahmana, Building a Law and Political Economy Framework Beyond the 20th Century Synthesis, in Yale Law Journal. So again, we have to figure out what is the 20th century synthesis. Well, I'll give you my review of it before we talk about what it is specifically. I think it's a very I think it's accurate. I think they have a very accurate and a nice description of the pincered forces, or the two forces that combine legally to reinforce racial subordination. And I'm sure from their perspective, they're speaking of wealth and income inequality more generally. However, I see it in terms of racial inequality especially. So I say this about it. The co-founders of the Law and Political Economy Project, they seek to reinvigorate a substantially defeated realist movement. They correctly identify the pincered attack on the anti-group subordination forces, but incorrectly assign it the label of neoliberal, which is typical. thereby leaving unacknowledged and unstudied the considerable influence of neoconservative ideology over the political branches. And this is not a criticism necessarily of these authors, but for me, a criticism of scholarship, progressive, radicals, whatever. I understand the role neoliberalism has to play in group subordination, wealth inequality, and all that, but there is also very much a neoconservative wing that attaches itself and perhaps even controls the neoliberal marketplace. So anyway, I'm glad that they acknowledge the neoliberalism of it, but I say here the first half of the 21st century synthesis they critique is in fact neoliberal when they're talking about the petrification of efficiency as a consequence to be considered in commercial legal context. At the same time, in constitutional or in rights related legal subject matter, that second half is neoconservative. Right? That second half is neoconservative, just as there may be a difference between radicals and progressives and whatnot. There is a difference between neoconservatives and neoliberals. So the first half of the 21st century synthesis they critique is neoliberal. The second half is neoconservative. Racially asymmetric market failures and imperfections that I believe is a framework that can address this 21st century synthesis, as I will explain in my upcoming book, Afro-Atlantic in Jurisprudence. I'm sure I didn't make that entirely clear, but I wanted to just speak on that before we got to their own words. So let's talk about their own words, how they describe this 21st century synthesis of limiting, not recognizing group subordination or inequality on the constitutional and the right side, but at the same time recognizing economic efficiency on the other when it comes to commercial context, and how that pincers the realist and the progressive, the critical movement. All right, so they write, we live in a time of interrelated crises, economic inequality and precarity, and crisis of democracy, climate change, and more raise significant challenges for legal scholarship and thought. Neoliberal premises undergird many fields of law and have helped authorize policies and practices that reaffirm the inequities of the current era. And again, I suggest that neoconservative forces consciously put these things in effect. The focus on neoliberalism, to me, asserts a sort of blamelessness, a certain naturalness, when I think there are people that are consciously influencing the market structures against equality and equity. Anyway, in particular, market efficiency, neutrality, and formal equality have rendered key kinds of power invisible. Power invisible, see? Again, that's why I think they need to invoke the neoconservative regime expressly, and generated a skepticism of democratic politics. The result of these presumptions is what we call the 20th century synthesis, a pervasive view of law that encases the market from claims of justice and conceals it from analyses of power. Okay, and that's again why I suggest racially asymmetric market imperfections is a way to see the market in that respect. That it's not concealed. It's quite obvious if you use the framework of asymmetric market imperfections. Anyway, they further write, to enter law school today, particularly the elite law schools that send the most students into powerful legal and political positions, is to join a conversation shaped by the depoliticization and naturalization of market-mediated inequalities. Okay. Beginning in the 1970s, but drawing from developments in the laissez-faire era and earlier, a new division of labor and legal thought coalesced into what we call the 20th century synthesis. And again, I always harken back to the 1970s when I talk about the neoconservative revolt against Brown versus Board of Education and the Civil Rights Movement. Anyway, it consisted of two interrelated moves. First, in fields denoted as about the economy, the rise of law and economics centered efficiency and sideline questions of distribution, power, and democracy. True. Second, in fields understood as more political, fields including constitutional law, for example, a parallel set of moves worked to render economic power hard to find and correct. True. It was background and not foreground, allowed to operate according to its own ostensible rules and protected in various ways from democratic reordering. Absolutely true. So I do not disagree at all with their positive description of what's going on. It is the prescription and the assignment of agency where I have just a little bit of a disagreement with these authors, but it is a fantastic paper. I will be citing to it, that's for sure. The result, as a matter of fact, Afro-Atlantic jurisprudence, I'm in the mode right now of creating a bibliography, and this is going in it. Might even use the term 20th century synthesis within in the writing. The result is a vision of constitutional equality and liberty that enshrines structural inequality and economic power. True. We must place the 20th century synthesis. We must replace the 20th century synthesis with a different framework for legal thought. At the core of this reconstruction is a renewed commitment to the questions of political economy. That's what I'm trying to do with racially asymmetric market imperfections. So this, for me, heat, fire, hot, hot, hot. Hot paper right here. Again, this is Jedediah, Britton-Purdy, David Singh, Grewal, Amy Kapczynski, Sabeel, Rahmana, Building a Law and Political Economy Framework Beyond the 20th Century Synthesis. Hot paper right there. Number 2, our second piece is Kudekallua, Fordham on Caste and Food Discrimination as Racially Asymmetric Market Competition. Ramya, Jawahar, Kudekallua, Race, Caste, and Hunger. 43 Fordham International Law Journal. This is my description this is my recasting of it in terms of racially asymmetric market failures, or at least dealing with the concept of caste in that rubric. Kudekallua contends that racial discrimination and caste discrimination are twin systems of discrimination, which can be represented economically in terms of racially asymmetric market competition to the extent members of a race or caste are relegated to specific non-lucrative occupations. Moreover, the concept of untouchability is applied to the Dalits, right? There's actually a group called the Dalit Panthers that's frameworked after the Black Panthers. Invokes racially asymmetric market information to the extent society considers them inferior, racially asymmetric transaction costs to the extent they must endure a disproportionate share of society's negative externalities like crime and pollution, etc., and racially asymmetric profit maximization to the extent the Dalit population are removed or withdraw from markets and society. So and also from a Pan-African or Afrocentric perspective, caste in India is not just a twin system of discrimination along with racial discrimination. It is all racial as part of a global system of white supremacy. Right? In other words, colorism or global colorism is just racism with a hierarchy based on distance from African heritage. Right? This essay, going from the words of Professor Kudekallua, this essay provides some, and this is an education. Again, pick this up just to be aware of the different systems of racism and discrimination around the world, to see what's possible, to see how they fight it, or to see what perhaps neoconservative forces that I just talked about in the last paper have planned for black folks in America, because again, we see caste rear its ugly head when it comes to COVID-19, and black folks disproportionately occupying the jobs that are on the front lines and are the most dangerous. So think about that when we talk about this real quick. This essay provides some content for the history and structure of caste in India. It contends that caste-based discrimination is a form of racial discrimination. This essay will illustrate this by comparing and contrasting experience of caste with race through the lens of both domestic law and international law. Finally, to investigate a specific dimension to the subject matter, this essay will present some evidence of the practice of discrimination in the politics of food and nutrition. To understand the fundamentals, the social structure is made up of 4 main castes or varnas. The hierarchy as follows. Within India, Brahmins are in the top class. The uppermost caste or the priestly caste are predominantly vegetarian, historically have full access to education, have participated in establishing institutions, and are viewed as gatekeepers of knowledge, be it cultural, scientific, or social. Kshatriyas, sorry, I don't speak the language, but the caste composing of soldiers or warriors, often the caste of monarchical families. Vaishyas, the caste composed of farmers, merchants, and traders. Shudras, the caste composed of manual laborers and domestic service. And the 5th excluded fraction is Dalits, who were seen outside of the larger system. Dalits are comprised of tribal communities, nomadic clans who would be responsible for manual scavenging, tannery, and sweeping. They are untouchable, which means that they are not allowed to participate in any activity with the other four castes. This exclusion is literal and in every aspect of daily life, including entering temples, residential homes, shaping spaces of education, and using the same water supply, utensils, and toilets. Now think about that, and think about the cast of folks within the United States that are forced to deal with COVID, and if it was even that much more serious and contagious, how we would treat those people, right? Dalits are placed outside the Varna system or the caste system and were not given any status in the caste social hierarchy. In both tradition and religious doctrine, they are considered polluted. In many ways, the caste system goes further than racial segregation because it not only poses segregation, but dictates what Dalits do in their segregated space. We're going to fast forward, right? There are Article 17 of the Indian Constitution abolishes the practice of untouchability, but it's not defined. Article 48 of the Indian Constitution explicitly recognized the lowest strata of the caste hierarchy with the intention of promoting special care in the education and economic interest of communities, protecting them from social injustice and all forms of exploitation. Now that's interesting. Again, for those that are in America that are looking for laws that more broadly protect those who have been subordinated in a group context. So this relates to the last paper very well when you're talking about a law and political framework. This essay moves away from the common themes of housing, education, health, and employment, but an investigation through food touches on all the above in numbers of ways. By providing some insight, this essay to engage with the idea that food policing transcends immediate discrimination, asserting that it has implications that are far-reaching, intergenerational, with long-term harm to communities' nutrition and wellness. And to me, that directly relates to human capital, right? When we talk about capital gaps or asymmetric market competition, we're talking about capital gaps, but not just financial. It's also human, social, and political. To the extent there are large gaps in the accumulation thereof, it will perpetuate racial hierarchy, racial subordination, and racial wealth gap. Finally, he writes, the caste system is the longest surviving social hierarchy in the world. I contend that it started in Egypt and that is well developed within Africa and has also its efficiency and developmental qualities as well. And the discrimination it perpetuates has deep roots in the Indian identity. Critical race theory, though much younger, is a much more developed framework, particularly when it comes to the articulation of inequalities. Fundamental contention is not that race and caste are the same, but it is that racial discrimination and caste-based discrimination are the same. The prejudices faced by communities entrenched in the rigidity of these identities can be regarded as widespread act of untouchability and continuum. I agree with that in a sense, but I go further. No, I think it is the same. I think they are both part of a global white supremacy as a construct, as a system, right? The Dalits are the people of India with the closest connection to African heritage. It is also my belief that in foregone prehistorical eras, India was in fact ruled or dominated by Nubians or Kushites or East Africans and what have you, and that the position of Dalits on the bottom is a redux or a revolt upon that systems began by the Aryans and et cetera, et cetera, et cetera, et cetera. All right, so great paper, very informative, very much welcome. So the third piece that we're going to do, the third and final piece, is again Camille, Lamar-Campbell, Getting at the Root Instead of the Branch, Extinguishing the Stereotype of Black Intellectual Inferiority in American Education, a long-ignored transitional justice project. It is in the 38th volume of Law and Inequality, a journal of theory and practice. My description of it, centering on school segregation and that myth of inferiority, is that racially segregated schools represent asymmetrical market imperfections, both in terms of the lack of truthful information available to Black people, as well as the perpetuation of racial stereotypes or the lack of truthful information available to Black people. So about and to. I didn't write that correctly on my notes. Transitional justice could use a framework like racially asymmetric market failures and imperfections to help explicate it. Right? And so from the paper, Professor Lamar-Campbell out of Nova Southeastern writes, despite Round 1's transitional character, the court's mandate to, and when she's talking about transitional justice, she's talking about well, I think she writes about it a little further, but a more sweeping remedial legislation designed to create what Stephen Breyer would probably call a fuller and more participatory democracy, right? Despite its transitional character, the court mandate to end segregation with all deliberate speed announced in Brown versus Board of Education 2 and its judicially fashioned remedy of integration did little to describe, to account for, or to establish a legal framework for correcting societal attitudes about black intellectual inferiority that spawned the adoption of segregation as an educational policy. I'm not sure I agree with that sentence, but I understand where she's going. But at the same time, I also offer a framework for that particular to deal with that inadequacy. However, I'm not certain that it was spawned, a school segregation was spawned by the myth of black inferiority. I think it was the myth of black inferiority is used to justify, but I don't believe it was to spawn. But furthermore, further from her paper, consequently, American public schools remain in transition, a perennially transitional system of public education that burdens black students with the yoke of an insidious stereotype injures all students and threatens the egalitarian ideas of public education. Consequently, extinguishing the stereotype of black intellectual inferiority in American education remains a long ignored transitional justice project. Okay. Further, more describing transitional justice. Given transitional justice's broad remedial focus, changing the law without other efforts to rectify the psychic injuries inflicted by stereotypes and biases leaves victimized communities without an adequate remedy for government-sanctioned wrongdoing. Unlike retributive justice, with its focus on punishing individual offenders, or restorative justice, with its focus on restoring relationships, transitional justice has a much broader remedial focus, societal transformation. To achieve societal transformation, successor political regimes adopt a comprehensive agenda of transitional practices to address human rights violations, heal fragmented societies, and regain the credibility of their citizens. Now that's very interesting. If America was very much committed to changing from the Jim Crow past, they would engage in these. But are we that committed? Doesn't seem that way. But again, this is a new opportunity, right? The George Floyd situation. So connecting black Americans' quest for educational equity to the larger struggle for international human rights will bring a fresh perspective to contemporary discussions about the elusiveness of Brown's unfulfilled promises and equip educational reformers with an arsenal of transitional justice practices to tackle stereotypes of black intellectual inferiority at the root of systematic inequalities in public education. This article builds upon prior applications of transitional justice principles to the desegregation of the United States public schools in two substantial ways. First, it incorporates normative understandings of transitional justice that have emerged since these initial scholarly insights. And second, it substantiates the validity of the comparison and then moves beyond theoretical considerations to more practical implications or adaptations. And again, I think this is great. I think that transnational approach needs a framework to actualize it. How would, again, an Asian judge or talk about racial discrimination with respect to black folks in a neutral way, in a way that reflects almost all group subordination instead of holding blacks out as special? And that's very much akin to the paper that we're dealing with when you're talking about affirmative action in the suit of Asian students being discriminated against with respect to Harvard's admission policy. So that type of framework, I suggest, is asymmetrical market failures and imperfections. To the extent you can show that you are trying to, that your policy of racial remediation or diversity or whatever is trying to correct, right, corrective the asymmetries that exist in the market, I think it should be permissible and not only consistent with, but I'm sorry, not it's not against equal protection. It is consistent with the idea that law should equally protect all of its citizens. So those are the three papers that we have in this week. Britton-Purdy from Columbia and others, Berkeley, Yale, Brooklyn in the house, Kudekallua from Fordham, and Lamar-Campbell out of Nova Southeastern. Three fantastic papers. We will be back next week with three more books or papers at the Economic Justice Law Review's Weekly Scholarship Digest. See you next week.